really excuse to come back to Houston. It's also a great honor to have Josh commenting on the talk, in addition to being one of my former students, which is probably his greatest distinction. He is also the author of what is the closest thing we have to a definitive account of the Obamacare litigation, his book Unprecedented, which does exist at slightly bigger form than that card that he has there. And certainly if you're interested in this case, I do urge you to read his book, but perhaps even better is my book, co-authored with several of the bipolar conspiracy bloggers that I'm going to talk about today. To be slightly more serious, I think if you only read one book about the Obamacare litigation, probably, to be honest, Josh's is the one that you should read because it gives the most comprehensive account. But I have a few things to say too, and that's what I'm going to try to do today. So in this talk, I'm going to cover a couple of major themes that are developed in much more detail in the book. One is the way in which the Obamacare decision by the Supreme Court encapsulates and exemplifies a broader conflict between two competing visions of constitutional federalism, and how this traces out in all three of the major arguments addressed in the case: the claim that the individual health insurance mandate is authorized by the Commerce Clause, the Necessary and Proper Clause, and finally the Tax Clause, and also within the court's ruling on the constitutionality of conditions placed on Medicaid money given to the states. In the last part of the talk, I'll focus on something which is perhaps unique to this book, which is the way the public debate over Obamacare developed and the role of the blogosphere within it, particularly the Bullock conspiracy, the blog for which I and the other co-authors wrote for. This is the first case where the blogosphere probably actually had a substantial impact both on the public debate and also on the types of arguments that were made to the court. So I'll start by laying out what I think are the two competing visions of constitutional federalism that clashed in this case. One, which you might call the New Deal vision, is the idea that Congress has the power to regulate virtually anything that has a substantial effect on the national economy. This is the way many liberal legal scholars and also many judges and others interpret the Supreme Court's decisions in the New Deal era, and they believe not only that this is the best interpretation of the Constitution or of those precedents, but also that it's essential in a modern world where we have a highly interdependent economy, where there are many complicated things going on, and therefore they say it's important that Congress have broad authority to regulate this sort of activity, or, as we'll see, also inactivity as well. The opposing view is that the court should more strictly enforce the textual limits on congressional power set out in Article 1 of the Constitution, which carefully enumerates the different powers that Congress is supposed to have, and therefore implies that any limits which are not enumerated or any powers are not enumerated are ones that Congress doesn't have. And this vision also has not just a doctrinal or legalistic dimension, but it also has a practical side as well, and that its advocates claim that far from being outmoded in the modern world, judicial enforcement of limits on federal power is actually highly desirable because the very complexity of the modern economy makes it difficult or impossible to plan it effectively for the center, and therefore what we actually want is decentralization and competition with more local initiative rather than Washington trying to impose one-size-fits-all solutions, such as, for example, Obamacare with its one-size-fits-all approach to health insurance. So I think these competing ideas run through all of the major arguments deployed in the Obamacare litigation, in particular the arguments on the constitutionality of the individual health insurance mandate. At least as originally envisioned in the text of the statute, what that mandate said is that by January 1st of 2014, this year, all Americans with exception were required to purchase federally defined health insurance of a kind outlined in the statute, and this was at the center of the Obamacare by 28 states, and also a number of private parties that the Supreme Court ultimately ruled on. Throughout the litigation, the main argument that the federal government put forward in defense of the individual mandate is the idea has to regulate commerce, and the commerce that it regulates must be interstate. And the individual mandate actually goes 0 for 2 under that test. Not having health insurance isn't commerce, it is the absence of commerce, and in addition, it isn't interstate either. And this common sense way is actually the way that the Commerce Clause more or less was interpreted by the Supreme Court throughout the first 150 years of American history, and it was the way I think the dominant understanding among the founding fathers as well at the time of the framing of the Constitution. If you instead argue that the Commerce Clause gives Congress the power to impose any regulations that have a significant effect on the national economy, it renders redundant much of the rest of what you see in Article 1. For instance, in Article 1, Congress is given the power to create currency or even to engage in to regulate foreign commerce or commerce with the Indian tribes, but Indian commerce, foreign commerce, the creation of currency and so forth, all of these clearly have an effect on interstate commerce, so you wouldn't need those other powers if the power to regulate commerce gives Congress the authority to regulate anything or create any laws that have an effect on interstate commerce. And you have an approach to the Constitution that renders much of Article 1 actually redundant, then maybe there's potentially something wrong with that approach, at least from an originalist or textualist point of view. Now, obviously, precedents since the 1930s greatly expand the scope of federal power under the Commerce Clause, and they did so even before the Obamacare litigation, and the court had said that the Commerce Clause actually gives Congress the authority to regulate, quote, any economic activity, and in its most expansive decision along these lines, Gonzalez versus Raich in 2005, where the court said that the Commerce Clause is broad enough to allow the regulation or to forbidding the possession of medical marijuana, even if the marijuana had never crossed state lines or been sold anywhere. They define economic activity as including, quote, the production, consumption, or distribution of a commodity, any activity that did one of those three things. Notice, however, that even under this extremely broad definition, and in my view actually badly flawed definition, I think Raich is one of the worst Supreme Court decisions in the federalism area ever, but even under Raich, the individual mandate doesn't qualify. Not having health insurance is not the production of a commodity, it's not the consumption of a commodity, and certainly it isn't the distribution of a commodity. So even under this definition, it doesn't seem like the individual mandate can qualify. So really, the only way to uphold the individual mandate under the Commerce Clause is to assume that the Commerce Clause gives Congress the authority to impose any regulations that have an effect on interstate commerce. There's no question, obviously, that forcing people to buy health insurance does have effects on interstate commerce, even if it doesn't actually regulate interstate commerce. And under that approach, it would mean that Congress would have pretty much unlimited power to impose any regulations it wants, because regulations of almost any human activity, or in this case inactivity, could potentially have an effect on commerce. Now, as it became clear that the courts were unwilling to give Congress a virtually unlimited blank check to regulate whatever they want, the federal government during the course of litigation developed several arguments to try to say that this is a special case. I call them in the book the healthcare special rationale for the individual mandate. I'm not going to go through all those arguments here, but I will note one that is the most common of those, the one most presented, and this is the idea that healthcare is special because everybody uses healthcare at some point in their lives, as opposed to, for instance, examples that were discussed during the litigation, such as the broccoli mandate, where the argument was made that if you can do this, then it would authorize a mandate requiring people to purchase broccoli. But say the advocates of this healthcare special argument, not everybody uses broccoli, not everybody enjoys it as much as I do, so they may prefer to purchase other kinds of food instead. But everybody does use healthcare, and that's what makes this a special case. I think the problem underlying this is that there's a bait and switch here. Instead of focusing on health insurance, which is what you're actually forced to buy, they focus on the broader category of healthcare. And of course, once you allow this kind of tactic, it can justify any other kind of mandate as well. For instance, not everybody enjoys broccoli, not everybody purchases it, but everybody does participate in the broader market for food, of which broccoli is only one part. In fact, they would suggest that the market for food is even more difficult to avoid than the market for healthcare. Just try avoiding it if you don't believe me, and I don't think you actually get very far with your efforts at avoidance. And of course, you can use the same kind of argument just by any other mandate as well. Consider a requirement that everybody purchase GM cars to help out the American auto industry. Certainly not everybody purchases cars or even uses cars, but everybody does participate in the broader market for transportation. Even if you walk everywhere, that requires you to buy shoes or socks or something else to pad your feet. So in that sense, you're still in the market for transportation, and thus you can still be subject to the mandate to purchase General Motors cars or any other kind of cars. I think other healthcare special arguments offered by the government share the same weakness, that if you take them seriously and apply them consistently, they could easily justify virtually any other mandate as well. Therefore, they underscore rather than diminish the force of the argument that this is actually a rationale for virtually unconstrained federal power. Recognizing that maybe it's difficult to defend a mandate under the Commerce Clause alone, the federal government also said maybe it can be defended based on the Necessary and Proper Clause combined with the Commerce Clause. The Necessary and Proper Clause gives Congress the authority to, quote, carry into execution other powers granted to the federal government under the Constitution. So maybe the Commerce Clause alone doesn't authorize this, but maybe the individual mandate was necessary and proper to help carry into execution regulations of the regulations of interstate commerce, in this case, commerce in health insurance. And the Supreme Court had for a long time, going back to McCulloch versus Maryland, defined necessary very broadly as anything which is potentially useful or convenient, and certainly an individual mandate is necessary in that broad sense for regulating interstate commerce. But it isn't just the necessary clause. It's actually the necessary and proper clause. And we have evidence going back all the way to the 18th century that the founders actually understood this as two separate requirements, the requirement of necessity and the requirement of propriety. And something which is necessary might still be unconstitutional if it isn't also proper. And this actually is the issue that I focused on in the amicus brief that I wrote in the Supreme Court, and also in much of what I wrote in this book, the argument that this is not proper. Prior to the Obamacare case, the Supreme Court had said that necessary and proper are two separate requirements. They said that in several cases, but they'd never given much in the way of a thorough definition of proper. In my brief and elsewhere, I argued that at the very least, a proper statute is one that doesn't depend on a rationale which gives Congress virtually unlimited power to mandate anything. As James Madison put it in 1790 in a speech on the clause, whatever meaning this clause may have, none could be admitted that would give an unlimited discretion to Congress. And of course, the federal government's necessary and proper argument in this case did exactly that. It did exactly what Madison said it wasn't supposed to do, in that if you argue that the individual mandate is necessary and proper, or is proper because it's useful to regulating interstate commerce, it has an effect on interstate commerce, then the same thing can be said of virtually any other mandate. So consider the broccoli mandate, requiring people to purchase broccoli surely has an effect on the interstate market in broccoli and perhaps other food. Requiring people to exercise every day may have an effect under productivity, which in turn has an effect on interstate commerce. And you can tell the story for pretty much any other mandate to do anything or not do anything that Congress might potentially care to impose. And this actually is the argument that ultimately was endorsed by 5 justices, including Chief Justice Roberts in his controlling opinion for the court. They endorsed the distinction between something which is merely necessary and that which is both necessary and proper, and they ruled the individual mandate was improper. In Chief Justice Roberts' opinion, he analyzed this by saying that what the necessary and proper clause allows Congress to do is to exercise powers that are, quote, incidental to one of the other enumerated powers, but not ones that are themselves great and independent powers. The way I like to explain this in slightly less legalistic terms is that under Roberts' analysis, building on things that Chief Justice Marshall said in the 19th century, you can use the necessary and proper clause to pin a tail on a dog to supplement one of the existing enumerated powers in a small way, but you can't use it to pin a dog on a tail. That is to create a whole vast new realm of federal power on the pretext that what you're doing is just implementing one of the enumerated powers and using the Affordable Care Act to create a federal power to impose new mandates of virtually any kind is clearly an example of pinning a dog on a tail. Though in fairness, the opinion by the Chief Justice doesn't go into any great detail on where the line between a incidental and a great and independent power actually lies. So I think this is an extremely important part of the Chief Justice's ruling. It has implications for future cases, and I think after the Supreme Court is very likely to have to return to this issue in the future. Finally, we come to the rationale under which the Chief Justice actually upheld the individual mandate in a modified form. He concluded that it should be upheld because it's a tax authorized by Congress's powers to impose taxes in the tax clause. This was an extremely surprising conclusion because this tax argument had been almost uniformly rejected in the lower courts, including by several judges who had upheld the individual mandate under the Commerce Clause or on other grounds. In fact, 15 out of 16 lower court judges who ruled on this issue rejected this rationale, and its Supreme Court oral argument, even with the liberal justice of the Supreme Court, seemed to be very skeptical of it. And what all of those courts have ruled is that this is not a tax, it's a penalty that basically it's a regulation that imposes a fine for failing to do something that the federal government has ordered you to do. Lots of Supreme Court precedent has distinguished between taxes and penalties. For instance, in 1996, the Supreme Court, in an entirely uncontroversial decision, had said that a tax is, quote, an exaction, a penalty is, quote, an exaction imposed by statute as punishment for an unlawful act. If you read the Obamacare individual mandate text, it fits this definition to a T. It says you must do X, buy a certain kind of health insurance, and if you fail to do it, then you have to pay this fine that's calculated in a certain way and collected by the IRS. Moreover, it's worth noting that I'm not the first constitutional law professor to suggest that this is a penalty rather than a tax. A much more famous former constitutional law professor said exactly the same thing back in 2009. I, of course, refer to former Professor Barack Obama, who said that for us to say that you've got to take responsibility to get health insurance is absolutely not a tax increase. And I think the president was absolutely right about that, and his lawyers, in their arguments that they made to the Supreme Court and Chief Justice Roberts, were in fact absolutely wrong. It's unfortunate that their lawyers did not adopt the official presidential position on this particular
No, he said
issue.
it wasn't a tax increase, not that it wasn't a tax.
Well, so you can save that for your response, but if it's not a tax increase, it's also not a tax because it clearly imposes a monetary payment that people have to pay that didn't exist before. So, and it doesn't create an offsetting decrease in taxes. So we can debate this later too when you'll get your turn. So returning to the tax or penalty, as it were, at hand. I think if you do adopt this approach, then there are virtually no limits to the range of things that Congress could try to regulate by means of these so-called taxes, because, of course, if you can have a tax for not having health insurance, you can have a tax for not purchasing virtually any other product, whether it be broccoli or a car, or even copies of Josh's book, or pretty much anything else that we might have out there. However, Chief Justice Roberts, while admitting that interpreting this as a tax is not the natural reading of what the statute is, he said it could still be saved from being unconstitutional by being reinterpreted as a tax, and he outlined 4 different distinctions which suggest that maybe this is a tax rather than a penalty. One is he says that it's a monetary fine. And therefore, that's different from penalties where there might be criminal penalties or jail time or the like. I think this is not a very powerful distinction because there are in fact many criminal laws and penalties where you're punished with a fine. Think of fines for speeding tickets, jaywalking and the like. A fine for jaywalking surely is not a tax, it's pretty obviously a penalty. He says also, well, unlike a actual penalty, this one is not so high as to be punitive. You have a real choice, he says, about whether or not you're going to purchase health insurance. This, I think, is true. For many people, it may well turn out to be cheaper to pay the tax than to purchase what is turning out to be the very expensive health insurance available under Obamacare, but I don't think this converts it into a tax. There are many penalties in the law which are low enough that you have a genuine choice whether you want to engage in a prohibited activity or not. Think of parking tickets. I bet many of you have at some point parked your car in a place where it's illegal to park, and you deliberately were willing to take the risk of getting a parking ticket because you knew that the parking ticket was not so high as in the Chief Justice's terms to be punitive. The same exact point applies to the Obamacare individual mandate. He then says, well, there's no scienter requirement, which in plain English means that the government doesn't have to prove that you intended to violate the law in order to impose this fine on you. Well, there are also other strict liability crimes that are on the book, so the fact that there isn't a requirement of intent also, I think, is not a powerful distinction. Moreover, the lack of an intent requirement here actually expands the scope of Congress's powers rather than diminishes it. And finally, he says that, well, the enforcement here is by the IRS, the agency which enforces tax laws. That's an indication it's a tax. I think that's just a bureaucratic distinction. If the IRS were charged with enforcing parking tickets or tickets for jaywalking, that wouldn't convert them into taxes, and the same point applies here. So the Roberts test, I think, has the defect that it gives Congress virtually unlimited power to impose taxes on almost any activity or inactivity, but it does have an important procedural constraint in that it says, well, the penalty can't be so high as to be punitive. You have to have a real choice. This has, I think, important implications going forward because it means if it turns out that not enough people purchase health insurance under this law to make the market work effectively, it may be difficult or unconstitutional for Congress to raise the penalty so as to give you a stronger incentive to buy the law. The so-called young invincibles, people like many of you guys, young healthy people, so far at least it doesn't seem like people like that are enthusiastic about buying Obamacare qualified health insurance because it's a bad deal for them in many ways, and for many such people it may make sense to pay the fine. If that's what's turned out to happen, then it's not clear that Congress now has the authority to raise the fine so as to give you guys a stronger incentive to purchase this kind of insurance. I think this issue of the problem of unlimited federal power also runs through the spending clause aspect of the Supreme Court's decision, where they at least partially invalidated the part of Obamacare that requires all states to expand the scope of Medicaid coverage or face the loss of all of their federal Medicaid funding. They're required under the original statute to include within Medicaid everybody whose income is 133% of the poverty line or lower, and otherwise they would lose all of their Medicaid funding, which for many states is as much as 20% of their entire state budget, not 20% of their Medicare funding. Federal funds for Medicaid are actually 20% of the entire state budget for many states, so it's a huge, it was a huge deal. The Supreme Court had, since the 1930s, given Congress broad authority to impose conditional spending grants on the states under the clause which gives Congress the power to spend money for, quote, the general welfare. But one of the few limitations that the court had said might be imposed on this congressional power is that the grants couldn't be, quote unquote, coercive. So you couldn't coerce the states, although you could incentivize them to do things. But the court from the 1930s until the Obamacare case had never struck down any spending grants on the basis that they are coercive or indeed on any other kind of basis at all. So it was quite surprising to many people when, by a 7-2 margin, in this case the Supreme Court did strike down this part of the Obamacare statute because they said that this was so punitive and imposed so much pressure on the states that it was in fact coercive. If you threaten to withdraw all federal Medicaid funding unless the states take this particular action, that is, as the Chief Justice put it, a gun to the head, and therefore is coercive as opposed to just offering incentive. I think in retrospect, we shouldn't have been so surprised that the court did this, even though, frankly, I was one of the people that was surprised, because if the Supreme Court was going to give the coercion test any meaningful teeth at all, it had to do so here, given the amount of money involved and given how the states really had no meaningful practical choice. Now, I must say that I myself am skeptical of the coercion approach to this. To my view, I would instead impose substantive constraints on what the general welfare means, but currently the coercion test is the only meaningful limitation on Congress's spending power, and if the court was going to limit this authority at all, it had to act in this case, which is why I think they ultimately chose to do so, because they didn't want to just give Congress a blank check in this area. So in all of the major issues addressed in the Obamacare case, you see this ongoing theme of the clash between the broad vision of federal power, which would give Congress the power to impose virtually any laws that affect the economy, versus a more narrow one that takes the enumerated powers limits more seriously. I've tried to suggest why I think that more narrow one is more correct. I think in the last few minutes I'll briefly talk about the development of the public debate over this case, and in particular the involvement of the blogosphere. As I discussed and my co-author discussed more fully in the book, there's a long history of Supreme Court decisions and litigation campaigns that took place in the court of public opinion, as well as elsewhere, as well as in the courtroom. One of our critics in an article in The Atlantic said, well, how dare you guys try to litigate this case in public? That hadn't been done before. That's not what lawyers do. Well, tell it to Thurgood Marshall and the NAACP. Tell it to the abolitionists who did this back in the 19th century. Tell it to the women's rights movement, the gun rights movement, numerous other people who have understood that in order to effect legal change in the Supreme Court, it's also important to take part in public debate. What I think was unusual about the public debate in this case was not that it occurred at all, but rather that a lot of it occurred in the blogosphere. My co-authors in this book and I were writers for the Volokh Conspiracy, a prominent legal blog founded by Eugene Volokh of UCLA, law professor, and several of my co-bloggers first developed many of the arguments that were used to challenge the individual mandate at the Volokh Conspiracy blog, particularly my co-blogger Randy Barnett of Georgetown Law School, who the New York Times called the Godfather of the Obamacare litigation. So one role that the blogosphere played was in helping develop some of the arguments, but another significant role was, I think, in changing the dynamic that the defenders of Obamacare tried to create at the beginning of this litigation, where early on they argued that there was an expert consensus that the individual mandate was obviously constitutional. So if you thought that it wasn't, either you're just a person ignorant about constitutional law, you simply don't know what you're talking about, or alternatively, you're just a Republican partisan hack. You're just twisting constitutional law for your partisan purposes. One of those two things, they said, had to be true. So at the Volokh Conspiracy, I think my co-bloggers were able to change this dynamic because people like Randy Barnett or others of my co-bloggers like Jonathan Adler, David Kopel, and others, they were leading constitutional federalism scholars. Moreover, as libertarians, they could not easily be dismissed as just agents of the Republican Party, because many of them had actually clashed with the Republican Party on a variety of issues in the past. So by presenting these arguments by leading experts, the blog was able to change the dynamic of this debate, and the fact that it was a blog had an important impact, I think, in a couple of respects. One is that thanks to Eugene and Randy Barnett and others, the blog had previously already had a large audience among legal professionals, reporters, and others who follow these issues, so these people quickly became aware of our arguments. Even if they didn't agree with them, they had to concede that they were a part of the debate. In addition, The blog offered us the advantage that we could respond very quickly to any new developments that might arise, new court decisions, new arguments that were developed by the two sides, and so forth. And the ability to participate in the debate in real time is an important innovation. In an earlier era, when legal scholars commented on Supreme Court decisions, they could do so only in law journals or other specialized journals that take months to appear, or alternatively, they could do so only in commenting to the mainstream media, and the media at that time often only interviewed a small number of law professors from a few elite law schools. The blogosphere, I think, greatly changed that dynamic. Now, I think it's important to recognize that the Boa conspiracy and my co-bloggers were far from the only factor that was relevant to this debate. Obviously, it made an important difference that the law was unpopular. If the law had been very popular, it's unlikely that 5 justices would have been willing to strike down large parts of it, and it's also unlikely that the case would have gotten to the Supreme Court in the first place. Obviously, the opposition of the Republican Party also made a big difference in the opposition of libertarians more generally. However, I think the political dynamic by itself would not have gotten the case to the point where it got. There are many things which are unpopular, but legal challenges to them don't get off the ground because there's not an argument for their unconstitutionality that's credible to legal professionals. Consider, for example, that Republicans and actually the public were just as unhappy with Obama's stimulus bill passed in 2009 as they were with Obamacare, but legal challenges were not successful because those challenges either would have been implausible or would have required overruling lots of Supreme Court precedent. So the difference here is that people like Randy Burnett and others were able to present arguments that not only accorded with a lot of public opinion, but also were credible to legal professionals. And it was the blogosphere, I think, which played a key role in driving that message home and driving home the message that there was a real debate here and that there were serious legal arguments. And I think, obviously, the blogosphere is likely to play a role like this in similar debates in the future. Obviously, already in the Obamacare debate, it wasn't just we who used the blogosphere. Also, our opponents did so as well and wrote a lot of important blog posts also. And I think that approach is likely to be imitated in future cases. So ultimately, what we have in the wake of the Obamacare decision is an ongoing clash over constitutional federalism. It can no longer be said that there's one single dominant view here that all experts share. I think that wasn't even true even before the Obamacare decision, but it's clearly not true now. We see this playing out in the ongoing debate, including ongoing legal challenges to the various aspects of Obamacare that are still going on. So I think there's a lot of room for Josh and others to write additional books, both about the ongoing battle over Obamacare and about the battle over constitutional federalism, of which this is just one part. And of course, Josh, like me, also writes blog posts about these issues. So I now turn it over to him so that he can explain where I go wrong.
No.
Thank you so much. It's something that's brief and Ilya here because I had mentioned he was my professor at George Mason. I heard him, every week for 4 hours a week talking about this and that, and I see so much of myself and him. So it's actually an honor to have him sit next to me at the table. So I don't think I disagree with Ilya about much. It's not really a good point to comment. What I want to talk about is constitutional change and how the Constitution changes. All right. So probably that 80% of you are in my class. For those who aren't, I'm sorry. But for those who are in my class, we talk a lot about what it is that doctrine changes. We talk about this arc of constitutional law, going from point to point to point. And what is it that changes? Now, we often hear this called the living Constitution, the living Constitution, this document that breathes and lives and bleeds and changes and adds and subtracts. But I think that only tells part of the story, right? The constitutional law has certainly changed. The Constitution itself hasn't. There have been 27 amendments. So this document has been basically identical for 200 years. But what's changed is constitutional law. And how does constitutional law change? I think Ilya and his colleagues at the Ball Conspiracy have illustrated this to a T. You have a couple dynamics at play. You first have to have what sometimes is called popular constitutionalism. It's the idea that popular will, the people, have a certain vision about the Constitution, right? What was so egregious, so terrible at Obamacare? Was it so bad that people were getting health care? Maybe, maybe not. But what was so egregious was how it accomplished this. The way it worked is that it forced you, to buy health insurance. There was a mandate. You had to buy it. And that didn't sit well with Americans. Right? We, especially here in Texas, we don't like being told what to do. If I want to sit on my butt and eat Doritos, that's what I'm going to do, right? Obamacare said, no, you shall maintain insurance. You shall buy health care. So that by itself didn't sit well with Americans. So you have this popular opposition to a law that wasn't like a bailout or something else. People did not like being told what to do. All right? But that's not enough to affect constitutional change. There are lots of things that we might not like. That change has to be coupled with a constitutional argument grounded in the text, history, structure, and the Supreme Court's precedents. Okay? Now, I can make up any crazy theory about why the government can't make me buy broccoli, right? But the genius of what Ilya and Randy Barnett, who wrote the foreword to my book, and others did, was they were able to form a constitutional argument that fit in with the text, fit in with history, and fit in with the Supreme Court's decisions. Okay? All of those things had to happen. They weren't advocating any change in doctrine. They weren't advocating that the court should reverse the New Deal. And this wasn't a Justice Thomas argument, right? They were arguing that within our framework, this is not allowed. And what was the primary leading cry? Well, to plug my own book, this law was unprecedented. Okay? Never before had Congress attempted to mandate that people buy a product. Okay? And if Congress had never done it before, I think I mentioned this in class yesterday, that's a good indication that maybe they don't have that power, right? If this power was never exercised over the course of 2 centuries, that might be a hint they don't have that power in the first place, okay? So you start with that. But you look at doctrine, okay? So we know about the Commerce Clause, we know about Wickard v. Filbert, that Congress can regulate any activity that has a substantial effect on commerce between the states. But what was here was different. This was a stroke of genius of Barnett and others. Congress wasn't regulating activity, no. They were regulating inactivity. If I'm not buying health care, I haven't done anything. What this law did was not only regulate activity, it forced someone who was inactive to do something. And think about that. Once the government can force you to buy a product, they can regulate it 99%. Once they make you buy a product in interstate commerce, they have full power. Okay? What about the taxing argument? Okay, so this was another thing that they had to kind of get creative on. The law itself, as Ilya mentioned, was labeled a penalty. The President of the United States said, this is not a tax. It's actually funny. He said, this is not a tax increase. And I swear his lawyer actually said in court, well, Your Honor, there's a difference between a tax and a tax increase. They actually made that argument in court. It's silly, right? But the law was labeled, I was just ribbing Ilya before. The law was labeled a tax, a penalty, right? All right, so you have to make an argument. Can the Congress call something a penalty when they actually say in court that's a tax, right? Can they disguise this broad taxing power under the harmless label of penalty, which is much more narrow, right? Then we get to the spending power. The way Obamacare works is that it tells states you have to provide health insurance to a lot more people, right? And the feds will pay the money for the first whatever years, and after the states will be on the hook for part. So what's the problem there? The states argue this is a form of coercion. You are coercing us to pay all this money we don't want to do. So they have to look to the court spending. We did South Dakota v. Dole. This is the highway case, right? What are the limits? Okay? And then we have the broader notion of federalism, right? This is the thing that's not appreciated. Who was the main litigants in this case? It wasn't people. As Ilya mentioned, the state attorneys general from Florida, Texas, elsewhere. There's this notion that the states are the protectors of liberty. Okay? That states exist to clash with the federal government, ambition to be checking ambition. And the states exist as the protectors of this freedom of the people. It was the state of Florida who led the charge to give sanction to the people's right not to be compelled to buy health insurance. This case brought together every aspect of constitutional law we studied, just about. And it pulled it together in record time. The law was passed March 23rd, 2010. By June 28th, 2012, it was done. So in the span of 2 years, we went from passing a law that almost every scholar thought was perfectly constitutional to getting 5 votes in the Supreme Court to say that Congress can't do this under the Commerce Power. 5 votes in the Supreme Court say Congress can't do this under the Necessary and Proper Power. And unfortunately, 5 votes in the Supreme Court say that Congress could do this as a tax. This is a remarkable story, and if you want to come to my class later, if you're not in my class, it's in room 416. I'm giving a 3-hour lecture on this case. You'll be dead from Obamacare today. But I need to commend Ilya and his colleagues because they did the unthinkable. They took a constitutional argument that came not quite out of thin air, but close enough. And in a short time, they sent it to the moon. And they came this close to winning. So after you read my book, read Ilya's book, and you can learn about how this argument came to be. And we have some time for more questions, which I'm much more interested in for Ilya. So thank you very much.
So I think I'll waive response for now, and we'll just get to the questions. We're running a little bit later than we thought we would.
And if you need to go for a 12 o'clock class, that's fine. Just excuse yourself when you need to go. So questions? Don't be shy. Yes, in the back.
I think it's been said that some of the ideas that Obamacare incorporated, that were incorporated into Obamacare for the proposed pass, came from ideas that were come up during the Nixon administration and conservative views. How substantially similar are those to the ones that are actually out in the first law?
Yeah, so I don't think there's a lot of similarity between Obamacare and what the Nixon administration sought to do. What the Nixon administration sought to do in the early 70s was actually an even more heavy governmental involvement in the healthcare system. Obamacare is a more system like exists in many European countries. There is similarity, between the Obamacare individual mandate and the individual mandate proposed by the Conservative Heritage Foundation beginning in 1989 and endorsed at various times by different Republicans, and even more similarity between Obamacare and Romney Care imposed by Mitt Romney when he was governor of Massachusetts. Essentially, in many ways, Obamacare is the federal version of Romney Care. It was even designed by some of the same advisors who had advised Romney. One of my George Mason colleagues said it's ironic that in 2012, what you had was a presidential election where there was a clash between the Jesus Christ and the John the Baptist of Obamacare, where obviously Romney being John the Baptist proclaiming the idea, and then Obama being Jesus Christ actually spreading it and implementing it.
It works on several levels, actually.
Yeah, so I don't mean to engage in blasphemy here, but there is some truth to this, that essentially the plan that Romney did in Massachusetts with some variation is the, at least on the mandate side, is the one that Obama did nationally. You can say, well, this means the Republicans were hypocritical to oppose Obamacare, and so on, and probably were, but of course, Obama himself also reversed positions on this in that during the 2008 election, he had denounced Hillary Clinton when Hillary Clinton proposed a plan that included an individual mandate. He even said that trying to solve the problem of lack of health insurance by requiring people to buy health care is like trying to solve the problem of homelessness by requiring people to buy a house. So there's a lot of politicians that have switched positions on this issue at one time or another. To my mind, what matters is not the motives of the politicians for supporting these things or opposing them, but rather, A, whether it's a good idea, and B, whether it's constitutional. And in my view, it's unconstitutional regardless of whether particular Republicans or Democrats had supported it at various times or not. The last thing I would say about this is that back in the 90s, when many Republicans did support an individual mandate, this was at the very beginning of or even before the modern trend where the Supreme Court began to try to impose at least some limits on the exercise of the Commerce Clause power. So in an era when most people assumed that there were no real limits at all, the Republicans could say, well, if the Democrats don't observe any limits, why should we observe any limits either? So what's good for the goose is good for the gander. As beginning in 1995, or in some cases, for some issues in 1992, the Supreme Court began to again enter into this area and put at least some limits on congressional power. I think that changed the nature of the discussion and nature of the ball game here.
Yeah, it's funny, during the debate between Romney and Obama, during the debate between Romney and Obama actually said to Romney, "You are the godfather of Obamacare." We had the GOP put out the worst conceivable candidate for the most significant issue of 2012. Romney was impotent to talk about Obamacare for the very reason that he invented it, and no matter how hard he tried to double back, he couldn't win that issue. And bizarrely enough, this might actually be an issue again in 2016. So watch out for this one: Hillary Clinton and Obamacare. Right? Obamacare is effectively the follow-up to what Hillary Clinton wanted. Hillary Clinton, in the 2000 election, wanted a mandate. So in other words, Obama's After Obama got the nomination, he stole Hillary's plan, then made it his own. And now Hillary's going to have to run against it in 2016. So stay tuned.
So I don't know if she's going to have to run against it. We'll see about that. But it is interesting that the mandate is, according to polls, the least popular part of Obamacare. Some 70% of the public opposes it and wanted it to be struck down by the Supreme Court. And it's ironic that this was the one part that Romney could not attack because it was the centerpiece of his own health care plan. He did attack Obamacare more generally on other issues. And obviously, it's also ironic that Obama ended up adopting this approach given that he had attacked it very forcefully in 2008.
All right. Other questions?
So I know that, I'm not familiar exactly with the law enforcement, but I'm aware that in working towards there is a small is that ground for another, third means of Obamacare in terms of like why? I guess when you come back and people come back and say, well, because you're not enforcing this, whatever, then we don't want to be.
So they can certainly say that. I don't know that there's a legal basis for saying, well, because you're not enforcing law, it should be repealed. There is a separate question about whether Obama has the authority to not enforce. This is being much discussed even as we speak. My very short take on that is that Obama can say, as the executive, we're not going to enforce this particular law, or we're not going to enforce it for a year or two. What he cannot do, what he actually has tried to do, is to say not only we're not going to enforce this law, but that it's actually not illegal for you to fail to obey these parts of the law until we say that it's illegal, until our waiver period ends. I think prosecutorial discretion certainly enables the executive to say, well, we're not going to prosecute certain people or enforce certain laws, even though what they're doing is illegal, but we're not going to come after you. Indeed, that's what's true of most illegal activity. The vast majority of Americans have committed at least one federal felony in their lives. One study suggests the average American commits 3 federal felonies per day, but the vast majority of those felons, or of you guys and other felons, don't get prosecuted because there aren't the resources to do it, and the federal government doesn't actually want to prosecute you. That's very different from saying the federal government can make an announcement, just the president alone, to say that what you guys are violating those laws is actually not even illegal in the first place. And this is an important distinction in that if it's just a matter that Obama has the authority to not enforce, but he can't actually immunize you from your activities being illegal, then that means at any time a future president could go back and say, well, all of you companies or individuals who did not obey the law during this period, we can impose these fines retroactively, and there could be other legal problems. So I think there is an important problem here, and part of what Obama is trying to do here probably is illegal. It doesn't in and of itself mean that the law will be repealed or should be repealed, but the fact that he has chosen to delay this enforcement and to claim that that he can waive obedience to these parts of the laws for a year or two is an indication of the political and practical problems that Obamacare is encountering. And this another unprecedented aspect of this case. Usually when Congress enacts a big new reform law or entitlement, it usually has strong enough political support that it's very difficult to attack in any significant way for years to come. Here you have a rare case of a major new federal program that is unpopular from the get-go, and if anything has gotten more unpopular since it was enacted, and that makes it more politically vulnerable than it was before. It also makes it more likely that various legal challenges coming down the pipeline might be successful because the court will not be constrained in striking it down by fear of a political backlash.
All right, one more question. Yes, sir, in the back.
So you mentioned that there was the one defense of Obama was a special status that Stephen has that everyone wants to use for something. And that brings up a lot of morality. It's kind of terrifying to think of one day enforced activity. So if you know this, I don't really know if it's possible yet, but what might be next to have this special status? What do you think is going to matter a bit more?
Yeah. So the Supreme Court actually rejected the various healthcare special arguments. Therefore, we don't know what would be next, given that this argument ultimately didn't prevail. It didn't prevail because 5 of the 9 justices did in fact recognize the point that I made, that if you poke at the details of this argument, it turns out that healthcare isn't nearly as special as the advocates of this argument claim. If that argument had prevailed, then I think it would have given Congress the power to impose virtually any other mandate, because virtually any mandate to do any particular thing can be described as part of this broader class of activities that could be mandated, and therefore ones that everybody engaged in at some point. I mentioned how you can justify the broccoli mandate in this way. The General Motors car mandate can also justify a mandate requiring everybody to read my book or to purchase it. Why? Certainly, maybe only a vast majority of people aren't actually going to read my book, but everybody is part of the broader market for information, of which my book is just one part, a very important part to be sure, but only one part. And so, therefore, because everybody's in a market for information, we can mandate that you get at least some of your information from this book rather than from other sources. We do have, I think, time for one more question. It's only 11:50.
Actually, they have class at 12, so probably we should let them.
Okay, so if you have a very quick question, you can ask it. How about that? Or if you want to go to class or go to lunch, that's totally understandable as well. Go eat some broccoli. It's actually good for you. In the process of writing this book, I researched this question, and it actually is much more beneficial for your health, perhaps even than Obamacare is.
All right. Thank you very much, Ilya.
Thank you guys for being here. As I had announced,
Actually, yeah.